This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Okay, on Wednesday, we covered a case where a prolific copyright troll named Richard Liebowitz, he's a lawyer, and he filed a case in Illinois, in southern Illinois, on behalf of photographer Glenn Craig, where Liebowitz later would go on to basically lose the case because it was in the wrong jurisdiction. Then he filed in the Northern District of Illinois, which was the right jurisdiction, but seemed like it was a weak case to begin with, so it was withdrawn. Now the court has settled the plaintiff with $24,000 of the opposing side's attorney's fees, but then Glenn Craig writes to the court and says he didn't know anything about this, and Richard Liebowitz has no authorization to file these cases. That video was Wednesday. On Wednesday, Richard Liebowitz filed this in his defense, saying that he is the victim here. I, Richard Liebowitz, hereby swears, under the penalty of perjury, that the following is true and correct to the best of my personal knowledge. I am the lead counsel for Glenn Craig, plaintiff, in this action and admitted to practice in this district and the state of New York. I submit this declaration in response to plaintiff's unsworn letter to the court dated July 8, 2020, to address the allegations made by plaintiff concerning my legal representation in this matter. Attached as Exhibit A is a true and correct copy of an email from plaintiff to my employees, Anthony Funchen and Donna Halprin, dated February 21st, 2017, in which plaintiff authorized our law firm to proceed with copyright infringement litigation against defendant Popmatters concerning the unauthorized use of plaintiff's photograph of jazz musician Miles Davis. Plaintiff's statement, no, indicates that Popmatters' use was not authorized, as opposed to okay, which means authorized. Plaintiff's statement, go after, means to file an infringement claim. And so, of course, I have the exhibit. Now, normally, you would not be able to reveal a client's confidential communications. And there's probably still a line here where Liebowitz could cross and reveal too much. But in the face of such a public accusation to the court, I think the rules of professional conduct do defer or do allow the attorney to defend themselves, but only so much. As far as I understand this, please, this is not legal advice. This is my basic understanding from law school 10 years ago. The attorney is allowed to reveal confidential information, but only as much as is necessary to rebut the accusation or false statement that was made to the court. At some point, there is revealing too much information. And so the fact that Glenn Craig said some things to the court doesn't immediately release attorney Liebowitz from all confidentiality obligations. It does, however, allow him to rebut it, in my best understanding. And so there's a bunch of links here, and you can see yes, okay, yes, okay, yes, okay, okay. And that's supposed to mean what? That's supposed to mean that okay means it's authorized. But then it says Jerry Jazz Musician, Hamilton and Hare, Melodic Distraction, Box Fit SD, and Popmatters, no, go after, which we now know means go after. Attached as Exhibit B is a true and correct copy of an email from plaintiff to Mr. Liebowitz dated January 22nd, 2018, in which plaintiff reminded me to file his infringement case against Popmatters regarding defendant's unauthorized use of the photograph. All right, and that Exhibit B is here. Hi, Rich, to remind you to file this week, BuzzFeed, Popmatters, Vice, Alshirts. Die you speak to Brandyn. Brandyn, are you secretly working for Richard Liebowitz? Please don't. As I asked, a check for $2,500 and one for $300. I have bills to pay this week and need badly. I will connect with Henry to follow up with what we did on Friday. Thanks, Glenn. And I have decided not to perform the caps lock that was on that message as a shout. I've just decided to read it straight, so I hope that's okay. Attached as Exhibit C is a true and correct copy of an email from plaintiff to Mr. Liebowitz dated February 8th, 2018, in which plaintiff asked me again whether I had filed his infringement case against Popmatters regarding defendant's alleged unauthorized use of the photograph. Here's Exhibit C. Hi, Rich. Once again, thank to you and Brandyn for the bail out. Any news, Universal. Did you file the following? Buzz, Fed, Dave Alexander, Popmatters, Miles, Vice, Scott Ashton, Alshirts, Dave Alexander, and anything else. Thanks, Glenn. And then attached as Exhibit D is a true and correct copy of an email from plaintiff to Mr. Liebowitz dated February 26, 2018, in which plaintiff reminded me again to file his infringement case against Popmatters regarding defendant's alleged unauthorized use of the photograph. And here we are. Hi, Rich. May we chat, my we chat later today. For the UK lawyer, we have these cases, The Arts Desk, Hamilton and Hare, Huffington Post, and Melodic Dist. Then for the USA, we still have BuzzFeed, Popmatters, and Al t-shirts. Thanks, Glenn. And attached as Exhibit E is a true and correct copy of an email from Mr. Liebowitz to plaintiff, dated September 11th, 2018, in which I notified plaintiff that his infringement case against Popmatters had been filed. The initial complaint was filed the same day, September 11th, 2018. Hi, Glenn. I hope all is well. Today, I filed your case against Popmatters Media. I should hear from their lawyers soon. Thank you best, Richard Liebowitz, Esquire. During the pendency of this action, I spoke to plaintiff numerous times about the case, including by telephone and in-person meetings at my office in Valley Stream, New York, and kept plaintiff apprised of developments in the case, including defendant's settlement offers, which plaintiff rejected as being too low. Respectfully submitted, Liebowitz Law Firm, signed Richard Liebowitz, Esquire. So, yeah, that's a real interesting one. He definitely is allowed to defend himself. I mean, I would feel really bad if, like, the law denied him, the right to defend himself in the face of such a blatant allegation. Like, okay, so let's be a little bit equal here. We don't like Richard Liebowitz in general, but lies against him are not helping the prosecution of Richard Liebowitz, and it's just going to cause things to be a little more complicated. One of those complications is going to be the rules of professional conduct regarding the confidentiality of information. Let's just go over these real quick for future law students, future lawyers, and, lawyers who are just need a good refresher. Like, hey, always a good idea to reread your rules of professional conduct. Can't go wrong. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. Paragraph B says a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary. 1, to prevent reasonably certain death or substantial bodily harm. So there you go. Certain death or substantial bodily harm, you can reveal confidential information. To prevent the client from committing a crime of fraud that is reasonably certain to result in substantial injury to financial interests or property of another, and in furtherance of which the client has used or is using the lawyer's services. So not just knowledge of a crime of great financial destruction, but also it has to be something that the lawyer is involved with. To prevent, mitigate, or rectify substantial injury to financial interests of another that has resulted from the client's commission of a crime. So that's possible. To secure legal advice about the lawyer's compliance with these rules, to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client, to establish a defense to a criminal charge or civil claim against the lawyer based upon conduct in which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation of the client. You can also, there's further exceptions, 6, to comply with other law or court order, and 7, to detect and resolve conflicts of interest. So in other words, doing your conflicts check. Number 5 is going to be our guy here, to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. So again, only reveal such confidential information as much as needed to directly rebut the claim or accusation, but never anything more. You can't go talking about other parts of the client's case or other personal details or other confidential information. So I kind of feel a little bad for Richard Liebowitz. I want to see him go down on the merits, not because somebody lied about their representation. And that's all I have for you today. I'll leave you with a short one on Friday. Thanks for watching. I'm Leonard French, your favorite copyright attorney. Thank you for your support on patreon.com/ljfrench and sponsors.com/law. You are what makes this channel possible. Speaking of people who make this channel possible, special thanks to BU1 Simmons. And thank you to our July $50 plus supporters, Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Cute Grills in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Gregory Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, and Brandyn Abel. And thank you to all of the $5 plus supporters who are scrolling on the LED panel beside me, and you are all in the description of the videos that drop. I love you all. I'll see you later. Don't forget, Sunday show, 10 a.m. on twitch.tv/lawfulmasses.